you for joining us. My name is Katie Perez, and I'm a Senior Associate here at Scott Legal PC. Today, we're going to spend some time talking about extraordinary ability visas and green cards, but just a few things before we get started. Some of you may know that the firm was founded on an ET visa several years ago. Our founder, Ian Scott, is in the U.S. on an ET visa and has been on several different visas, including the F-1, a TN, a B, and the H-1B. Scott Legal is a full-service immigration law firm, and we offer immigration services in several different areas, including E's, TNs, L1s, family immigration, employment immigration, national interest waivers, EB-1, and extraordinary ability visas, and more. So we will continue this webinar series doing at least 2 webinars a week on different topics. And at the end of this webinar, we will send you several useful tools. We'll send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. So this webinar will be recorded and available on YouTube. We will also send a link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We also send you a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout the presentation, please put them in the chat box and we will address them at the end of the presentation. So today we'll be presenting the first half of the webinar. We also are joined by another senior associate here at Scott Legal. We have Jiyae Hwang. Jiyae is another senior associate, and she has a wealth of experience adjudicating and preparing these petitions for the EB-2s, EB-1As, O-1s, and green cards. Jiyae earned her undergraduate degree from Harvard University and her law degree from NYU School of Law, so she has a lot of experience, and we're lucky to have her join us today. So let's get started. All right.
Perfect.
So we'll get started discussing the extraordinary ability visa categories. So the first ones we have listed here are the O-1A and the O-1B, which are both temporary non-immigrant visas. So with these visas, you can come to the U.S. and work here temporarily. So in contrast, a green card would be something you would obtain and intend to stay in the U.S. permanently. So again, we first have the O-1A. This is the temporary non-immigrant visa for individuals with extraordinary ability extraordinary ability in the sciences, education, business, or athletics. It's a very high standard in which you have to be one of a small percentage who's risen to the very top of your field in your profession. We also have the O-1B. So this is another temporary non-immigrant visa for people with extraordinary ability in the arts. So O-1Bs are treated a little bit differently than the O-1A. The standard is a little bit lower, and the person must have received distinction, meaning a high level of achievement evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Within the O-1B, you do have another kind of a subcategory for people who have this extraordinary ability in the motion picture and television industry. The standard for the motion picture television industry would be a little bit higher. You have to show that you have a record of extraordinary achievement in the motion picture and television industry that's evidenced by a degree of skill and recognition significantly above that ordinarily encountered, to the extent that the person is recognized as outstanding, notable, and leading in the field. So this would really just be a comparison to your peers within the industry. So let's see. So we also have the green cards. So for people of extraordinary ability. So first we have the EB-1A. This is similar to the requirements for what you would find with the O-1A and the O-1B, but there's not a separate category for the arts. So this category is for people with the extraordinary ability in the sciences, arts, education, business, or athletics, and it's all under one umbrella within the EB-1A. So the individual must be someone who is of a small percentage and who's risen to the very top of their field of endeavor, and that you have sustained this national, international acclaim, and your achievements are recognized in your field of expertise. So importantly, the person for the EB-1A must be coming to the U.S. to continue to work in that area of extraordinary ability. Just as a note, if someone who's had this very prominent career, they're very successful, and they just think they want to come to the U.S. to retire, then that wouldn't really work for the EB-1A. The government would want you to provide a statement of proposed intent, what you plan to do in the U.S., and it does need to be related to your field of extraordinary ability. So we also have next is the EB-2 National Interest Waiver Green Card. This one is not always lumped in directly with the extraordinary ability visas, but it's a good option for people who maybe were on the O-1B previously, but they don't quite meet that EB-1A standard yet, but they still do have a very impressive background, and you're working on an endeavor in the U.S. here that has a substantial merit in national importance. So you can be eligible for the EB-2 National Interest Waiver Green Card. If you're a member of the professions holding an advanced degree or its equivalent, you have a bachelor's degree and 5 years of progressive work experience, or you're a person who has exceptional ability. So these are the threshold requirements. And then if you're claiming the exceptional ability, you would need to explain how your area of exceptional ability directly relates to your proposed endeavor. It's important to note the term endeavor is more than just your general occupation. So you should be able to provide details, not only like what the occupation normally involves, but the type of work you propose to do and what you're specifically planning to undertake. So you would want to really provide, so as an example, if you are going to say you're coming to be an engineer, then the explanation of the proposed endeavor should really describe the specific projects and the goals you plan on taking on. So you would need to provide a detailed description explaining that proposed endeavor and provide the supporting documentation to establish that this endeavor is of national importance and has substantial merit. Within the EB-2, you would also need to show that the individual is well positioned to advance that particular endeavor. So you always need to keep in mind there needs to be kind of a nexus between everything you are proposing to the government. A connection between your occupation, your goals, the proposed endeavor, what you're planning on doing, so that you can argue to the U.S. that it's beneficial for you to be here and for the U.S. government to waive that normal labor certification requirement and do that labor market test. So one other note with the EB-1A and the EB-2, these are petitions that you can do yourself, so you can self-petition. So with these, there's a little bit more flexibility in some ways than someone who might be applying for the O-1A and the O-1B. So for those temporary visas, the O-1A and the O-1B, you would need to either have a U.S. employer, a U.S. agent, or an agent operating for a foreign employer. Okay, so we'll discuss just a little bit about the O-1A visa requirements, what you need to demonstrate. So for the O-1A, you can provide the government with evidence that you have a major internationally recognized award, something like the Nobel Peace Prize or the Pulitzer. Those are not that common, so much more commonly people are going to qualify on the basis of showing that they meet at least 3 out of the following criteria. So 3 is the minimum, but if possible, you always want to show the government that you are eligible in more ways, then yes, you should provide them as long as you have that strong evidence and to really show that you are at the top of your field. So we have first is the receipts of nationally or internationally recognized prizes or awards. So here for this criteria, you would want to consider, look at the award, look at is it really national? Is it the whole nation? Is it international? That would be more than one country. A prize is something offered or striven for in a competition or a contest. An award you would want to consider, this is something that's conferred or bestowed upon someone, especially based on their merit. So things to consider with this award would be the criteria for winning the prize, the past honorees, the number of prizes and awards given that year, limitations on the competitors, those kinds of things. So you, as an example of maybe what something to consider with an award is maybe you won an award while you were at school at university, and this just coming off just saying it's an award from a university, this might not be that compelling because maybe they do this competition every month at your school and it's just limited to students. So if you were trying to show the government, hey, I won this award, this might not be that compelling. It might not really show that you've risen to the top of your field. So you may not want to provide this evidence. However, if you were at a university and you won a very prestigious award where other professionals in the field maybe competed against you, then you would want to include this as part of the evidence for your petition, because it would really show that, hey, I have risen to the top of my field. Look at all these other contestants who are really accomplished and work in the same field as you. So you also have membership in associations in your field, which require outstanding achievements. Here you would want to really consider, does this membership actually require you to have an outstanding achievement in order to be invited and to apply to become a member of that association? So you would really want to look at the requirements for entry. So can anybody enter? Can anybody become a member of this organization? Factors you might want to consider would be that maybe the membership does not require outstanding achievements would be, is it based on a level of education? Is it based on paying a fee? So something like the Bar Association for an attorney, this would not be something you would want to show the government to show you're a member of an organization requiring outstanding achievements, because anyone who has passed the bar can join the bar by paying a fee. So it doesn't really require that outstanding achievement. So we also have published materials in professional or major trade publications or major media about you and about your work or something you've been working on. This should really be about you, but the publication can cover a broader topic if it's, it's related to something you are working on. If it really just does discuss your work in detail and mentions you in connection to the work, you could provide this as part of the evidence. But the government will focus heavily on whether or not the article was about you. We also have original scientific, scholarly, or business-related contributions of major significance in the field. So an original contribution can be something like a patent, it could be processes, something you've developed yourself. It is important to show how the work has already impacted the field. Potential impact is not sufficient for this criteria. Often people commonly provide testimonials about your work for this criteria, and those testimonials will provide the potential impact, but that would not be sufficient. You do really want to show how it already has impacted the field. We also have authorship of scholarly articles in professional journals or major media in the field. This can include publications in professionally relevant journals or published conference presentations at national or internationally recognized conferences. This criteria often, I would say, applies to those who are involved in academics, but it could apply to other fields as well. Next, we have a high salary or other remuneration for services as evidenced by contracts or other reliable evidence. So for this, you could provide, like it says, contracts. You could provide other, your pay records, that sort of thing. But you would want to also provide to the government a comparison just to show how your salary, what you earned, was high in comparison to others in the field where you're working. So you could show this by providing the labor statistics. And then I always tell people you do want to make sure you're comparing apples to apples. So if you're going to give the government an hourly wage that you earn to show it's high, then you'd also want to compare it to an hourly wage, not an annual wage. Okay, we also have participation on a panel or individually as a judge of work of others. So here you could show that you've served as a judge of the work of others in your same or allied field. An example of this could be reviewing abstracts or papers submitted for presentation at scholarly conferences, or serving as a peer reviewer for scholarly publications. To document this, you could just provide something like an email from the journal requesting you to review these journal articles, and then showing some type of evidence and maybe another email confirmation showing that you did complete the reviews. Another one we have here is employment in a critical or essential capacity for organizations with a distinguished reputation. So here you'd want to explain your role within the organization in detail, how it was critical or essential. Critical is that you've contributed in some way that is of significant importance to the organization or establishment's activities. Essential would be, was your role integral to the entity? Generally, a leadership role within an organization would satisfy that your role is essential to the organization. There is another part of this criteria that you do need to consider. So you have critical or essential, but you also do need to show that the organization is distinguished. So I always give the example, if you're a CEO of a very small company, then you could easily show that your role is critical or essential, but maybe the company's not distinguished. So conversely, if you worked for a company like Apple, this is a very well-known company, very distinguished, but if you're someone just kind of working in the factory, then your role is probably not very essential or critical. Okay. So we'll go over now just the O-1B visa requirements. We'll discuss a little bit about that. So again, the O-1B is for the arts and those in the motion picture television industry. The O-1B does have a very similar structure to the O-1A, in which you can provide evidence that you've earned a very significant award, a national or international award, something like a Grammy or an Oscar, something like that. But again, those are harder to come by. So you may want to provide the government with evidence that you've earned at least 3 of the following types of evidence. So first we have that you can show the government that you have performed and you will perform as a lead or starring participant in a production or event with a distinguished reputation. So evidence could include something to show that you were like a lead role, a principal role. A starring role means, something of great prominence relative to others within the production or the event. With this criteria, I think generally the hardest part is showing the future element. And I think that's the part the government really does focus on, because it can be hard to get evidence to show that your future production will have this distinguished reputation. Because in a lot of cases there might not be the critical reviews or advertisements yet. So that can be the hard part with this element. So we also have critical reviews or other published material in professional or major media by or about you, the applicant. I think here with the difficulty with this criteria can sometimes be showing that the media is major. The government doesn't hold much weight to articles that you can self-publish or they are not vetted versus an article that you might have in the New York Times. So you would really want to provide evidence to demonstrate that you've been recognized for achievements that are nationally or internationally recognized, and then again, just make sure that the media you can show is major. Okay. So next, we also have you could show the government that you have performed in the past and that you will perform in the future as a lead or starring or critical role for organizations or establishments with a distinguished reputation. So here with this one, it is important to remember that you're trying to show that your role is with the organization, not just an event or a production that we discussed previously. So a lot of times people conflate these two elements, but really they are distinguished. So you can think of your role with an organization as probably something more permanent versus an event or a production that we discussed previously. You could try to argue both, but again, I always tried to distinguish, critical role would be more specifically for the organization, not just an event or production. And a way to think about this is maybe you're working with a production company and you're going to star in their movie. You could probably satisfy, that first element we talked about, starring in an event or production versus maybe you work for the movie production company as CEO. So that would be you working for an organization specifically versus just an event that's more temporary. Okay, I'll go to the next slide. Okay, so we'll show another one we can discuss is evidence of a record of major commercial or critically acclaimed successes in the performing arts, as shown by box office receipts or record, cassette, compact disc, or video sales. So as you can notice that this one does have a lot of kind of outdated types of evidence you could provide for it. Most people don't have record sales or cassette sales anymore that they could show to support this element. So you might have to be a little bit more creative. For example, for showing commercial success. So maybe you don't have those record sales, but you do have the channel on YouTube and it's very successful. You have a lot of subscribers, which does translate into you're earning a lot of money, something like that. You can then show to the government, hey, I do have commercial success. Um, that one I do think you need to really support and explain thoroughly why it would amount to commercial success, because I do think the government can be pretty critical of um, the YouTube channels and stuff like that. While it is pretty mainstream and people know what YouTube are, they do sometimes push the burdens on you to show that it is that commercial success. If demonstrating that critically acclaimed success, the evidence should just demonstrate, that you have received this public-facing praise or these positive reviews in the relevant field, so such as from professional art, television, film critics, that sort of thing. Okay, so we next have evidence of significant recognition for achievements from organizations, government agencies, or recognized experts in the field. This one, a lot of people do, I feel like, provide as supporting evidence because you can, can provide it as a testimonial. You would really want someone signing that letter who is a recognized expert in the field. You would want to give their background, their credentials. Within that testimonial, you would really want to make sure that it's focusing on your achievements. A lot of times, 'cause I used to do the adjudications for these with USCIS, you would get people providing all these testimonials, and they would just speak to someone's their characteristics that, they're a hard worker, they're a great person, that they really do qualify for this O-1B, but that's not significant or sufficient. The government really does focus on the achievements, so you detailing what the achievements were. So we also have evidence of commanding a high salary or other significantly high remuneration for services in relation to others. So we did just kind of discuss this with the O-1A, and it would be similar. You would want to provide a comparison of your salary to others in your field doing the same type of job as you. You could provide as supporting evidence, the labor statistics, that sort of thing. And again, you would just want to compare um, the same categories as apples to apples. If you are providing that hourly wage, make sure you do, again, provide that hourly wage to the government. So lastly, within the O&B, there is something called comparable evidence. So let's say you are applying in a very niche field. When I was an adjudicator, I always remember the example they gave was that someone actually applied to be like a bodyguard of a celebrity. That was their O-1B category. So it's a very niche field. You're as a bodyguard, you're not having all these articles written about you in the New York Times, likely. Maybe some people are, hopefully for good reasons. But anyways, it could be very hard to demonstrate to the government that, hey, I do qualify for this O-1B. I am outstanding in this field and I deserve this visa. Um, so sometimes you do have this weird field and you still need this visa. So you can show the government that these criteria don't apply to you. But you would also need to explain why they don't apply to you. And that can be the difficult part. And you would need to, provide this comparable evidence, as what's listed in the regulations. So as a previous adjudicator, I would say this is like a really big hurdle to meet. It is something you can consider. Again, maybe you're a bodybuilder or not, I'm sorry, bodybuilder, a bodyguard for a celebrity and you want this or you need this visa. But in all the years I did do these O-1Bs, O-1As, I didn't ever have anyone actually satisfy this part. They always mix it up somehow. So just one more note on the comparable evidence. It's not available for those in the motion picture television industry. So it would be limited to the O-1B arts. Okay, so this is just, we have a little table here to kind of go over just summarize everything. So just the differences between the O1As and the O1Bs. So again, the O1A is for the sciences, education, business, and athletic fields. The O1B is for those in the arts and motion picture television industry. The standard for the O1A would be one of a small percentage who have risen to the very top of their field. The O1B, you do again have those two categories, the arts and the motion picture. So for the arts would be a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. And then for the O1B motion picture television industry would be a level of acclaim substantially above that of your peers. So again, that comparison is kind of in relation to those in your field, the movie, motion picture, and television. So how long can you get these visas? For the O1A and the O1B, you can receive the time, you can get up to 3 years. Again, it would depend on the work you have, your events. So you would need to show the government that you're asking for 3 years, but then you need to also show that you have work already lined up for those 3 years. If you are asking for 3 years, but you give them a contract that's only covering 1 year, then they would probably limit your time. So you do need to cover those 3 years. As a note for that, you could show you have work at the beginning of year 1 and then year 3, and there could be a gap, but then you could be eligible for that 3-year work visa. If you are here working, you already have this O1A or an O1B, and you want to extend your time, you can get another year. However, you can also show the government, hey, I have this new job, this new employment, I'm eligible for another 3 years. So that's possible as well. Let's see. So can your family come? Yes. It is possible to bring your spouse or if you have children with you, if they're under 21 and unmarried, so they can attend school here, but unfortunately your spouse, if they need to work or they want to work, they wouldn't be permitted as the dependent of the O1. Let's see. So it's possible if you had a spouse, they may just need to get a different type of visa. Okay. All right. So we'll discuss just, the EB-1A requirements. So this is really similar to what you would find within the O1A and the O1B. Some of the language is a little bit different because it does incorporate the arts, sciences, education, business, and athletics all together. So the structure is similar, where you can qualify with winning some type of major award. Again, like a Grammy or an Oscar, that sort of thing. However, again, most people don't have those really prestigious awards, so they would want to show they meet at least 3 out of the 10 criteria here listed in the regulations. Um, so a lot of them are very similar to what we discussed, and I'll quickly read through them. I'm not going to give the examples, but just for reference again. So you could provide evidence of receipts of lesser nationally or internationally recognized prizes or awards for excellence. You could provide evidence of your membership in associations in the field which do demand that outstanding achievement of their members. Evidence of published materials about you in these professional or major trade publications or other major media. Evidence that you have been asked to judge the work of others, either individually or as on a panel. You could also provide evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance in the field. Evidence of your authorship of scholarly articles in professional or major trade publications or other major media. Evidence that your work has been displayed at artistic exhibitions or showcases. Evidence of your performance of a lead or critical role at a distinguished organization, and then evidence that you've commanded a high salary or other significantly high remuneration, and then evidence of your commercial success in the performing arts. Okay. Okay. So I think we'll switch to Jiyae if you're ready, and she'll
Yeah.
discuss just the requirements for the EB-1A a little bit more.
Yeah, so let's talk a little bit more about how to qualify for the EB-1A green card. Now, as Katie mentioned, went over in the last slide, the requirements do sound quite similar to the O1A standards. And it's also similar that you would want to show at least three out of the 10 criteria if you don't have a major internationally recognized award, such as Nobel Prize, Pulitzer Prize, or Emmy, or Grammy, or something like that. Now there is this Kazarian analysis that USCIS has been using since that case came out a while ago, which is that not only did they expect that you would be able to show at least three out of the 10 criteria evidence, and assuming that we're in this latter camp, not necessarily the Nobel Prize camp, um, USCIS would basically look at your case in two steps. So the step one is whether, to determine did you actually provide three out of the 10. So have you, for example, if it's, media, did you submit any media about you, and if you're, meeting judging, have you submitted any evidence about judging anything, right? And then if it's award, lesser award, like have you submitted any awards that is responsive to the plain language of the three out of the 10 criteria. But what USCIS would do then is if the answer is yes to that step one analysis, they would actually have another step, which is called a step two analysis, final merits determination, where they would not only just look at whether you've checked, three out of the 10 boxes, but whether holistically speaking, if you look at the entire record, does the record, I guess both the quality and quantity of the evidence, does the record as a whole show that, tend to show that you are someone who has reached the very, very top of your field, and has received national or international acclaim by your outstanding achievements? Are you among the very small percentage? Does the quality of the evidence submitted demonstrate that you are one of the very small percentage? So, for example, let's say in a case where you submitted one media article, one judging activity and one, award, and maybe it was a very small award, or maybe, maybe the judging was also not a very major event, or maybe the media article, it was not a media article in the New York Times or Forbes or, The Guardian or something like that, but it was a smaller type of media. And if that's it, then maybe when they're looking at the quantity and quality of the evidence, USCIS will maybe deny the petition on step two, saying that, well, if you look at the evidence as a whole, this record is not tending to demonstrate that you're one of the very small percentage who has reached the very, very top of the field, just because of what holistically the evidence is presenting. However, it is worth noting that on January 28, 2026, a federal district court in Nebraska actually ruled that this two-step Kazarian analysis was ultra vires. It's not, something that's consistent with the regulatory framework, the legal framework of the INA. And they actually reversed a denial that was based on this final merits determination test. Um, while the decision is not binding across the country and only the relief was limited to the person who appealed, it can serve as a persuasive authority. And yeah, we may see, maybe USCIS would change its course on how they are applying this Kazarian two-step analysis. So more changes could be coming in the future. As of now, there has been this ruling in January 2026, which provides some indication of potential changes in the future. All right, so now let's go on to the next slide, and we'll talk a little bit about the EB-2 National Interest Waiver green card option. Now, the EB-2 NIW is not necessarily an extraordinary ability, uh, type of green card, but there can be particular overlap. There can be areas of overlap with the types of applicant profiles who, find themselves considering extraordinary ability petitions, and maybe the profile is a little bit different. Maybe the person's not as famous as would, merit an EB-1A case, but maybe the project that they're working on is so potentially explosively helpful to the United States. Maybe an NIW could be an option for a green card as an alternative if, the person is having trouble meeting the criteria. Different, you know, uh, yeah, both green card pathways have very different um, uh, regulatory adjudicatory framework. So really, there's really no saying like which one is harder than the other. There is no hard and fast answer to that as a categorical matter, but depending on the person's individual profile, an NIW may be a better fit, EB-1A may be a better fit. Really, this is a individualized assessment that you can make. So let's go through how you would qualify for an EB2 NIW green card pathway if that is within your interest. The first thing to note is all EB2 NIW green card applicants must also meet the EB2 threshold requirement, which is the common requirement required for both perm petitions and also NIW petitions. No matter if you are getting an employer to sponsor you or no matter if you're trying to qualify under the NIW framework, you do need to first show that you meet the EB2 threshold requirement. So you need to meet the threshold requirement by either showing the two uh, channels through which you can prove the threshold. Either you show that you have an advanced degree, which is defined as a master's degree or higher in your field, or the equivalent of an advanced degree, which you can show by showing that you have a bachelor's degree plus 5 or more years of full-time post-baccalaureate progressive work experience in the profession that's related to your degree. So it is interesting to note that when we speak of 5 years of full-time experience, it's not just the period that matters. It also matters how your duties have changed over time to include more senior level duties, include more complex responsibilities as time went on. And if you don't have that progressive element, you will have trouble persuading USCIS that your bachelor's degree plus work experience is indeed equivalent to a master's degree. So those are the two ways you can qualify as a advanced degree professional. Now, if you don't have the bachelor's, if you don't have the work experience, or if you don't have the master's or higher, there's another way you can qualify under the EB2 threshold, and which is by showing that you have exceptional ability in the sciences, arts, or business. And in order to show exceptional ability, it is important to note that exceptional ability is a much lower standard than extraordinary ability, which is the standard we've been talking about in the context of extraordinary ability visas. Exceptional ability is defined as a level of expertise that is significantly higher than what is ordinarily encountered in the field. So it's definitely different from having to prove that you're one of the small percentage who have reached the very, very top of your field and have received international or national acclaim and recognition. So to show exceptional ability, you do need to show that you are someone who is recognized as someone who is operating at a level significantly above what is ordinarily encountered. So you would show that by meeting at least 3 out of the 7 evidentiary criteria. And this includes things like any degree or diploma that's related to what you do, licenses that's applicable to you. If you have 10 or more years of full-time experience in your field, you can also use that. Evidence you have commanded a high salary compared to others in your field. Membership in a professional associations that's relevant to your field. And importantly, if you can show that you've received enough recognition for your outstanding achievements from, your peers, government institutions, professional institutions, associations that cover your field, that can be in the form of awards, it can be in the form of letters, it can be in the form of media articles written about you. Really, you do have the freedom to, pull from many different sources to show that you have received that recognition. So definitely there is a little bit of flexibility on how you can argue each of the criteria. And you can see already that the required evidence is very different from what we just discussed in the EB-1A context. So meeting exceptional ability is another challenge, very different challenge. But if you can show, if you have enough evidence to show that you have exceptional ability, you don't need to have a master's degree or a bachelor's degree or the 5 years of experience in order to qualify for the threshold itself. Now, the more important challenge is to show in an NIW case why your case merits an NIW, which is a waiver of the normal requirements of having, a U.S. sponsor, U.S. employer to sponsor you, and having that U.S. sponsor go through the labor certification process, which is, testing the labor market to see if there is anyone else in the U.S. who is willing and able to take your job. But the NIW, because you're asking for a waiver from those requirements, you do need to show additional factors that make your case special to convince the USCIS to, allow you to basically self-petition for a green card. So thank you, Katie. So there are three prongs of the matter of dinosaur requirement that you need to provide enough evidence about to have your case qualify for the, NIW green card pathway. And the first prong is that the applicant is expected to prove that their proposed endeavor has both substantial merit and national importance. So what does that really mean? So when we speak of a proposed endeavor, the endeavor can really be in a wide variety of fields. It can be in business, it can be in health, education, science, or technology. And endeavors that tend to further human knowledge in those key areas tend to align well with what the government thinks could have national importance and substantial merit, because those types of endeavors that further human knowledge for the field as a whole, those tend to have a broader impact, a broader positive impact than just, the ordinary work arrangement where you would provide good services to one employer or your immediate clients. So the important question when you're thinking about the first prong is what is the future impact of your work and how is it important to the United States? Definitely must have a broader impact than just benefiting one's direct employer or direct clients. And it should be more than just providing good services in your field. Some examples of what can align well with the national importance framework are things like, research endeavors that tend to advance the cutting edge of a technology that will impact the field by, if you're publishing patents about this technology and if those patents will be shared with others, if you're presenting at industry conferences about some of the new research findings that you're having, if you're publishing research publications on academic journals, things like that. If in that way, if you will be helping the research of other experts in the field, those types of more public-facing, broad endeavors tend to work well with this framework. Some of the examples that are discussed in the case law and in the USCIS policy manual include things like endeavors that tend to improve manufacturing practices, endeavors such as medical advances, such as an endeavor that seeks to develop a new drug for or a new cure for a disease. If you do that, then everyone will use it. Everyone will be able to use it and benefit from it. And it'll also have broad public health benefits if you are, saving more lives due to this new and more effective treatment for a disease. So things like that that tend to have a broader impact on the United States, those would align well with the first prong to prove that your endeavor would have substantial merit and national importance. The second prong to prove is that the individual's well positioned to advance the proposed endeavor. So here you want to focus on your education experience, your track record of success in similar projects, any intellectual property that you've previously developed and published. You can show how those were already impactful, which can support the claim also that your future research will be broadly impactful as well. Any advancements toward the proposed endeavor can also be used to prove that you're well positioned to advance the proposed endeavor. So, for example, if you are an entrepreneur and if you're proposing a startup idea for, national importance, something that will really, help the industry. And let's say you've received investment for it. And let's say you've been selected to participate in Y Combinator or Techstars or, prestigious accelerator competitions or things like that. And you can show that there has been a lot of traction and interest generated about your project. Those types of evidence can be very useful in showing that you're well positioned to advance the endeavor because you have already made progress in developing the idea to that point of public recognition. So definitely you can use evidence like that. Finally, the final third prong in the national interest waiver matter of Dennis or test is that there must be a showing that on balance it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And the easy way to understand this is sort of like a balancing test. So at one end of the balancing test is the US government's need to protect the US labor market. That is why there is that requirement, which is, relevant in the normal situation where a US company wants to hire a foreign national for a permanent job. First, they need to test the US labor market to see if there is any other, US worker who is minimally qualified and able to do the job. But there can be countervailing considerations where we do want to give this, spot to a foreign national because maybe they're doing something that can have broader systemic benefits that will advance the field as a whole, which, another person cannot do. Or B, maybe they have very special skills and experiences that can't really easily be replaced by just another US worker with minimum credentials. Maybe they are the author of a patented technology that, that's really pushing the envelope of the field. And not everyone who has minimum credentials in that area can do that. So yeah, you can speak to your unique credentials and experience and record of success. You can speak to the broad systemic benefits and economic benefits that your particular endeavor can bring. And entrepreneurs can also use the fact that if you are, if you're granted a green card and if you're developing this startup business, for example, and if you'll be creating a high number of jobs, that in itself is helping the US labor market by creating even more jobs than, the normal interest of saving, those job spots for US workers. So there are a variety of strategies you can use to argue the third prong, but keep in mind that all three prongs must be met in order for an NIW petition to be approved. You can't just meet prong one and not meet prong two, or you can't just meet prong two and three and not meet prong one. All three prongs must be supported by strong evidence, and the USCIS must agree that you have met all three prongs before they will approve your NIW case. So practically, NIW cases are not very easy to overcome the burden of proof. But I mean, NIW cases are still being approved, although it has gotten a little bit more exacting than previous years. Definitely speak to an experienced attorney if you are considering the NIW approach. You really want to make sure that you're making the most precise arguments possible and have the most precise understanding of the strength of your case before choosing this pathway. All right, so let's move on to the next slide. So let's talk a little bit about expert opinion letters, which is an important element in all of the extraordinary ability visa categories that we talked about, including EB-1, O-1, and also it is an important element of NIW petitions as well. What is included in expert opinion letters? So for these types of petitions, we usually have clients obtain expert letters from key individuals in the industry. And this can include, letters from past employers. This can include letters from peers. This can include letters from clients or, business partners. If you're working on a project or if you're working on a research project, you're a research partner that can talk about, what you're doing in the context of an NIW. And in the context of extraordinary ability petitions, you would usually get, letters from people who can speak to your past achievements. So you can see the focus of the content of the expert letters is a little different depending on the type of petition we're talking about. For extraordinary ability, O1 and EB1A, most of the letters would be looking at what you've done in the past, so your past achievements and why they were extraordinary, why those achievements were significant, why did what you did have a major impact in the industry, so really past looking. Now for expert letters that we use for NIW petitions really depends on what prong you're trying to defend. But if you're trying to get support for the national importance prong, you need to look at a future-looking type of content because for that, the government wants to know what will be the prospective impact of what you're doing in the United States. What is the prospective impact of your proposed endeavor? How will the field change if you bring this project to completion? How will this improve medical practices? How will this improve manufacturing practices? So those type of future-looking statements can be supported by expert letters. If you're also trying to support the well-positioned prong, talking about how well you're positioned to advance this endeavor, then the letters would talk about your past achievements and talk about why what you've done in the field before and why was that impactful and how does it prepare you to drive forward this new endeavor. So really, the preparation of expert letters is a very tailored process. It really depends on the type of criteria you're trying to support, really depends on the type of application. The content is highly tailored. And generic template type letters are very not effective for USCIS adjudications, really because kind of AI generated, letters with generic language, they may look nice by someone who's just reading it, but when USCIS officers are looking at it, they really want more concrete details about exactly what you've done and exactly how it was impactful. Just saying that something was impactful doesn't make it so. Just saying that what you did was extraordinary doesn't make it so. Officers are really looking for that granular detail, the concrete detail, and we can help you, develop the right content to effectively do this persuasion. Who is writing the letter? So, especially for extraordinary ability petitions, we want to make sure that the letter writer has the right credentials to provide a persuasive opinion. So the letter writer themselves should have ideally many years of experience in the field. We would likely attach a full-length CV of the letter writer to make sure that the USCIS officer understands the background of where their assessments are coming from. How does the individual know you? So we would have a mix of independent letters and inner circle letters, what we call inner circle letters. And it depends on what we're trying to prove. So let's say you're trying to prove that your achievements to the industry were of major significance to the field. In that case, if somebody doesn't know you personally, but they know you because of your achievements, and they can speak to why that achievement was important for the advancement of the industry, an independent letter can be very powerful because USCIS officers will think, oh, well, this is a more objective assessment because these two people haven't worked together before. So this is, kind of an industry third party, really affirming the importance of this, innovation or, this original contribution to the industry. By contrast, if you're trying to talk about a critical role in an organization, and if you're trying to support that, you want to have that testimonial come from the organization itself. So this would be someone who you've directly worked with, who's part of the organization that you're trying to say you played a critical role in. And this letter would provide a personal testament regarding what you've done and why it was important to the organization. So really, yeah, we tend to use a mix of inner circle and independent expert letters. They both play a different role. Um, and yeah, you definitely want to work with a lawyer who can, give you targeted guidance on how to use expert letters that can be the most effective for your case. And specificity, I already talked about that, so I think we can go on to the next slide. All right, so some particular considerations, strategic considerations when you're comparing all of these visa options. Which category should I apply for? What are some of the considerations that can come to your mind? So the first question to ask is, do you want to stay in the United States temporarily or permanently? And what are your needs for travel? And do you anticipate staying long term in your home country, for example, as opposed to staying in the United States? Now, the O-1 visa, they are non-immigrant temporary visas, so they are well suited for those of you whose intent to work and live in the United States is temporary. By contrast, EB-1A and NIW are both green card options, and at the end of a successful NIW petition, at the end of a successful EB-1A petition, you will get a green card, which gives you the right to live and work permanently in the United States. Now, do note that though, that if you become a permanent resident in the United States, you also have responsibilities. So there is, in order to keep your permanent resident status, there is sort of a minimum period of time you need to stay in the United States, and there is a limit to how long you can stay outside the United States. So definitely, that can be an issue, and there can be tax considerations as well. We don't advise on that, but there can be many different considerations when you're, considering where to make your permanent, place that you stay. One thing to note, though, about the O-1 visa itself is that as long as there is a continuing work opportunity in the United States in your area of extraordinary ability, it is possible to continue extending the O-1 visa. There is no global time limit like the 6 year limit for the H-1B, for example. The O-1 doesn't have that absolute limit to how many times you can extend. So that's another consideration you may want to keep in mind. The other question to ask is, do you have a U.S. employer or agent, or do you want to self-petition? Now, technically, the O-1 visas require either a U.S. employer or U.S. agent to drive forward the petition. The O-1 visa is not for a self-petitioning type of petition. So you will need a separate legal entity or a separate person to act as either, the employer or the agent. One thing to note, though, is if you're an entrepreneur and if you create a new corporate entity in the United States, that legal entity can actually function as the petitioner because one, it is a U.S. legal entity, and two, it is considered a separate, legal entity as the beneficiary themselves. So you can use that even if you have ownership interest over that entity. So definitely get in touch with us if you want to explore more about that possibility. By contrast, the EB-1A and NIW are both green card options that allow self-petitioning, which means the foreign national person themselves can be the petitioner who drives forward the petition. So if you don't have any ties to the United States, or if you don't have that separate legal entity that can act as a petitioner, the EB-1A and NIW don't require that. Other considerations, family considerations, as Katie mentioned in the previous slide, for the O-1 visa, your spouse and children under 21 can join you in the United States as O3 dependents, and they can go to school in the United States and they can remain there while you're there, but cannot work. Work authorization is unfortunately not available for O3 spouses. By contrast, if you are applying for the green card under the EB-1A or NIW framework, your spouse and children under 21 can join you as derivative beneficiaries, and they also can get green cards, which provides, all the rights, including, the right to work. And if you choose the I-485 adjustment of status pathway, there are attendant benefits to that you can apply for, such as work authorization and travel authorization. Your spouse, beneficiary, and children can also join you in that application and be eligible for those benefits as well. All right, so we will move on to the next slide. Considerations when moving from a non-immigrant visa to a green card. So 3 points to consider in this situation. So qualifications. So it is important to note that even though similar language regarding extraordinary ability is used in the O-1A context, as with the EB-1A context, practically the way that the criteria is evaluated is much stricter in the EB-1A context. It is really the first priority green card pathway, and USCIS officers are very well aware of that. So they will take a very exacting view on everything. So in reality, those petitions, the EB-1A petitions, are much more carefully scrutinized. Qualifying for an O-1A or O-1B, and especially if it was an O-1B, this does not mean that you automatically qualify for an EB-1A. So you will want to have a fresh set of eyes, look at your O-1 petition package and see if switching to an EB-1A is indeed something that can be done. And if there are some weaknesses in terms of meeting certain of the evidentiary criteria, you can maybe take some time to bolster those areas where you lack evidence before trying for the EB-1A, because you will get, a stricter evaluation on those standards. And I'll quickly go over the rest. timing, consider how much time is left on your current underlying visa, because filing for an NIW or an EB-1A underlying petition by filing the I-140, that in itself can be considered as an expression of immigrant intent. And certain types of visas are harder to extend or renew once you have made that expression of immigrant intent. So definitely reach out to an immigration attorney to get a good sense of what the risks are, because that depends on the type of visa that you have and try to extend. Family. If you have children who may also need the green card in the future, definitely consider filing early to avoid issues with aging out. Once the child reaches the age of 21, they will no longer be eligible for the green card as a derivative beneficiary. So, and the green card process has multiple steps. So you do want to make sure you have secured the I-140 approval early enough. And there can also be priority date delay issues. So definitely a good idea to start early if that is part of your plan. All right, we will move on to the next slide. So the last question we will go over before ending, and I'm sorry that we've went a little bit over time, but are extraordinary ability categories available for entrepreneurs? And the answer to this question is a resounding yes. And there are several reasons why this can be a good option. EB-1A and NIW are self-petitionable categories, which means both are possible options for entrepreneurs who would likely not have a third party company that is willing to sponsor them through the traditional labor certification process. Because they have ownership over their companies, it is often not possible for entrepreneurs to go through the traditional, job seeking, perm-based um, employment employment-based green card. However, the EB-1A and NIW, if you can show that you meet the criteria, you can self-petition as the beneficiary, as the foreign national. Changes in the NIW standard under matter of Danizar, which is the current governing AAO case for the standard since December 2016. It has made NIW a much friendlier category for entrepreneurs. Now, NIW has been receiving increased scrutiny over the recent few years. So approval rates have definitely fallen a lot since 2016, 2017, 2018. So definitely get in touch with us to, discuss the latest adjudication trends to get a more realistic view of success in this area. So it is possible to apply for an O-1A visa if you're an entrepreneur. And I mentioned this in the previous slides, but there must be a separate corporate entity, a U.S. entity that can act as the petitioner, because it is not possible to self-file as a foreign national. But if you have this separate company that can, drive forward the petition, that is certainly a possibility. Okay. I don't think we have any questions that have come up. But yeah, Katie, thank you so much for leading the discussion, and thank you everyone for participating.
Yep, thank you, Jiyae.